Hi, and welcome to Beasley Boorman Lawyers. Today we're going to look at driving under the influence of drugs in New South Wales.
Hi, and welcome to Beasley Boorman Lawyers. My name's Josh Boorman, and I'm a solicitor with Beasley Boorman Lawyers. I've just come out of Campbelltown Local Court here in Western Sydney, where I appeared on quite a serious matter, which basically my client was very lucky today to escape full-time custody or jail time. Today, the matters which were before the court included one charge of disqualified driving, which was not his first offence. He had already had two prior drive whilst disqualified offences in the last 5 years. He had a second charge of drive under the influence of a drug, namely methamphetamine. He also had another charge of minor drug possession. These three charges were before the court today, but also my client had a previous offence, or several previous offences, but a previous offence of drug possession, which he was on a Good Behaviour Bond for under Section 9. And basically, these three charges before the court today, namely the disqualified driving, the drive under the influence, and the drug possession, were all in breach of his prior Good Behaviour Bond, which meant that he had to be resentenced on that prior drug possession charge. So these offences are serious in themselves, but what made this matter extremely serious and very touch and go as to whether our client would go to jail or not was the fact that he had a bad record, a bad criminal record and a bad traffic record. And basically, a bad record does add up over time, and it can really increase the seriousness of the way in which the court will deal with these the particular matters before the court. What we were able to do and establish from the outset was that our client had a serious addiction to methamphetamine, otherwise known as ice, and it is an insidious drug which is a real blight on our community, and it's really causing problems in all areas throughout Australia. So basically what we were able to do is my client pleaded guilty to all of these charges from the outset, so he attracted a discount for an early plea of guilty. The court was willing to have him assessed for a merit program, which basically is a magistrate's early rehabilitation program, which a drug and alcohol rehabilitation program, approved by the court system. And our client went along initially. He got assessed as suitable to attend that program. This was a 16-week program, quite an intensive course. And after my client was initially found suitable to proceed with the program, every 6 weeks the court would have us come back to court and do a progress report on how he was going with that merit program. It was really good for my client to get into the program because there was no doubting that he did have a drug problem with the methamphetamine. He had probably up to 10 drug possession offences over the last 5 years since he did become addicted to ice. So every 6 weeks we would come back to court, we would give a report of how he was doing in the merit program. And I'm happy to report that he did stick with the program. Each time we came back to court, the coordinator at Merit said he was going well and that they had suggested to the court that he continue on. So he completed the full 16-week course. But then after that, he was ordered by the court to go along and do a pre-sentence report. Now, a pre-sentence report is where a person is ordered to go along to probation and parole and speak to a corrective services officer, a case manager, who interviews them, goes through all the features of their life, to do with their home life, their work life, their prior criminal offending, their attitude towards the current charges and offences before the court. And they also explore other penalties or alternatives other than full-time jail custody. Unfortunately, the pre-sentence report came back saying my client was unsuitable for community service. And this was because he had previously done 150 hours community service. But due to his erratic behaviour, he did take too long to complete that 150 hours. He did complete that prior community service order. However, it did take too long and he was given previous warnings for non-attendance. So unfortunately, that cancelled out one penalty option that the court could have delivered. So he wasn't suitable for community service. So basically, the court needs to look at other alternative penalties, and certainly, given the seriousness of the disqualified driving offence, because it was, I think, his third or fourth disqualified driving offence within the last 5 years, and also the major offence of drive under the influence of drugs. These were offences, major traffic offences and criminal offences, which could have seen my client actually get locked up today and do some time in prison. What I did is I gathered some evidence together for my client. We worked together. We got the report from the merit program, which showed that he successfully completed the drug and alcohol rehabilitation program. The pre-sentence report suggested that he continue on with his drug treatment. But I was also able to get well-prepared statements from his mother explaining to the court the problems that their son has had with ice and methamphetamine addiction, the problems it has caused from a family perspective, and the fact that it really has almost torn their family apart. I was also able to get a statement from his current employer to basically give the court some insight as to what he does do for work, the fact that he does have stable employment, and the fact that his employer has been very compassionate and can see that my client is a good person if he can get himself away from the drugs, and has continued with him to provide him with stable employment. We're also able to tender documents to the court to show the court that my client had been going through financial hardship due to his drug dependency. He had racked up huge amounts of debts on credit cards, small loans, and various other financial issues. And we were able to show the court that he was doing something about this, going through a debt consolidation company to try and avoid bankruptcy. So it wasn't a pretty situation for my client that he has been in. He has taken the right positive steps to get on top of his drug addiction with ice. To the court that my client really has been trying to get on top of his drug addiction and his drug dependency, and also show that all these offences in the past and before the court today have ultimately been as a result of his drug addiction. And it's pretty well known that people who suffer from methamphetamine addiction do tend to act very erratically. They do tend to show little disregard for the law, and that certainly held a lot of weight when we look at his prior offences of driving whilst disqualified, because he knew that his licence was disqualified, yet he found himself behind the wheel of a car driving. So we were able to present all that before the court today, and really pull at the heartstrings of the magistrate. We were lucky to get quite a compassionate magistrate today who could see the reality behind his offending behaviour, and ultimately it was due to his methamphetamine addiction. But the magistrate could also see that he has really made a strong effort, to get himself clean, get himself off drugs and away from people he used to associate with who were heavily involved in the drug scene. And the magistrate was willing to give our client one last chance to continue on with his drug addiction treatment, and to let him remain in the community and to continue forward in his life with his employment and trying to mend the relationships that he's torn apart within his family. Ultimately today, the minor drug possession, which was of cannabis, was dismissed under Section 10. So no penalties were given in relation to that. No action was taken in regards to the breach of bond, the breach of Section 9 Good Behaviour Bond that he was given little under a year ago. So that was very good, because he could have been resentenced on the prior drug possession charges. In relation to the two very serious charges before the court today, the drive under the influence of a drug, namely methamphetamine, he received an additional good behaviour bond under Section 9 for a period of 18 months. So basically, if he comes back before the court again, having broken the law, then he will be resentenced on that particular drive under the influence of drugs charge. A habitual offender declaration is delivered on people who have 3 major traffic offences within a 5-year period. And basically it means that they need to serve an additional 5 years disqualification, which is very heavy, off the road after they have completed their court-ordered disqualification. So that habitual offender declaration order was quashed by the court, which means that he will not have to complete that additional 5 years set down by the Roads Maritime Transport Department, or the RMS. Drive whilst disqualified, which was a repeat offence. The magistrate did suspended under a Section 12 Good Behaviour Bond. So basically it means that for the next 8 months, he is on probation. If he appears before the court or breaks the law in any way during that period of probation, 8 months probation, then it is almost certain that that Section 12 Good Behaviour Bond will be revoked and he will have to go into full-time custody and serve out a period of 8 months. He was also disqualified for 2 years for the DUI offence and the drive whilst disqualified. They will be run concurrently at the same time, not on time. So ultimately, my client was extremely happy that he was able to avoid a full-time jail custodial sentence today, and it was a very big relief to be able to get him the result we did so that he is able to attend to his drug issues and to be able to remain in his stable employment. It's certainly his last chance, and he's very well aware that if he is back before the court again in anywhere in the near future, then it is most certainly going to be full-time jail for him. So guys, this is just one matter that we've dealt with today at the Campbelltown Local Court. Certainly if you find yourself in a situation where you have any alcohol or drug-related traffic offences or any other sort of criminal offences, then rest assured that we offer the best representation that you can find. We work hard to prepare case and present it in a way which really does look at obtaining the best results in court. So guys, if you are in this situation, please feel free to give me a call on 02 9283 8622, or alternatively visit our website beasleyboorman.com.au. There's plenty of information there on all sorts of offences, penalties, laws, blog posts, a whole raft of information, drug programs, traffic programs, a heap of information that you should make yourself aware of if you find yourself in a situation where you do have to attend court on criminal or traffic charges. And like I said, I'm happy to have a free first telephone consult with you just to give you an idea of your situation, discuss how we can best prepare a case for you. And if you want to get us on board to provide you with quality legal representation, then happy to have a chat with you. So give us a call 02 9283 8622. Thanks for tuning in, guys. Cheers.